You're interrupting my proceeding and while your phone is on also. Court does call the case of the people versus Dallas Williams.
I'm sorry. Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Good morning, Your Honor. J. Grant Miller, P58658 on behalf of Dallas Williams. Please state your name.
Dallas Williams.
All right. Ms. Williams, it's good to see you other than a little small box on my screen. All right, what are we doing?
Your Honor, we just need to plead impossibility at this point and then waive it over to the circuit court.
Not sure why you would have to do that, but so he's just doing a waiver.
Yes, Your Honor, there's a waiver in the file.
So you're waiving your right to have a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed.
Yes, sir.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
All right. People also waive their own.
Yes, Your Honor.
Preliminary examination having been waived, defendant bound over to circuit court on a single count. As to the arraignment,
Waive former reading, stand mute, Your Honor.
defendant having waived former reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
March 11th at 1:30 before Judge Conlon.
March 11th, 2026, 1:30 before Judge Conlon.
Thank you, Your Honor.
Thank you.
Your Honor, before we close
Yes.
the record, I also spoke with the defense counsel about having his client agree to move the bond payment over to child support arrears.
That we went through this and typically that is done at arraignment automatically, but let's see if this slipped through.
Your Honor, I just learned he posted bond last night, but we don't oppose the being applied to the
He
arrearage.
just posted bond last night.
I just
Right,
found
but
out.
the bond. Right, but the order that if he did should have been done at arraignment. Yes, and it on December 19th, 2025, there's an order from his arraignment that bond to be released to, and then it states the case number.
This happened January 2nd already to circuit court.
It already went over.
That did, yes.
So it's already gone over.
Correct.
All right. So we checked and that was the date of the order was in December, and then January 2nd, I'm informed or something like that. It went over to circuit court from 15th District Court. Okay.
And I do believe the concern is my client has several child support cases. We want to make sure that that bond is applied to this child's case. There's only one current case active.
Only one what?
One current arrearage case that I was able to find in the city
For Washington.
for Washtenaw County. I don't know of any other counties currently.
So I can just tell you, now that I can find it again, the bond form clearly indicates that it is going to be paid over on case 2013 298 DP.
If there's any problems, I'll reach out to the
Okay,
DA's office and
it.
we'll rectify the city.
Sure.
Your Honor.
It's being paid over to the case that's in the complaint. So,
Perfect. Thank you, Your Honor.
Thank you.
good. All right. Thank you, folks. What?
And he also.
What do you mean we lost Elman? Okay, where are all the people? Well, not you guys. I see you. Where are all the attorneys?
Happy to go out on my way out and see where they're at. Right.
Yeah, when you go out and tell them I'm like really angry.
I'll tell them that you're giving out free kittens. They'll get them all coming.
Okay, that's a little weird. I say just tell them I'm angry. Free kittens. Hey. Thinking of all the stuff I've done in my life, I've never driven away free kid.
The courtroom session opens in confusion as the judge immediately confronts an unknown individual interrupting proceedings with phone turned on, demanding to know who they are and why they are speaking. The court then calls a case of the People versus Dallas Williams, where attorneys announce their appearances and the defendant confirms his identity. The prosecution explains they are pleading impossibility and waiving the preliminary examination, a decision the judge questions before carefully advising the defendant of his rights. Dallas Williams acknowledges that by waiving the preliminary hearing, he is giving up the chance to challenge probable cause and will instead proceed directly to circuit court. The judge accepts the waiver, enters a not guilty plea on the defendant's behalf, and schedules pretrial proceedings, briefly addressing bond issues related to child support before closing the matter.
I don't know what he said. Well,
We were here a long time, but I'm in that room.
what do you mean we were here a long time?
Oh, she knows. They're there.
No, they said they've never seen you before. No. All right, but
I don't know where the prosecutor is with,
I have no idea. I've seen one prosecutor, and that's the Attorney General. I've not seen any Washington County prosecutor.
oh, he was in here, Mr. Yeah, you were here early.
Oh, well, lo and behold.
It wasn't him, but the
As
other one.
we speak.
He's not my prosecutor.
Yeah.
I'm in the conference room though.
What?
So, I'm in the conference room with a client.
Okay, so you're not ready on your case?
Well, we're ready. He said he had to look to see if his people were here, the prosecutor, not this prosecutor. He had to look to see if his people were here, but we could come in.
Ms. Farnwell, who are you?
Bond guy.
The bond guy.
Sorry.
Who is it?
Mr. Cook.
Oh, Mr. Cook.
He's talking to someone in the conference room. I'll go grab what case?
Oh, no, I'll wait. You guys figure out what you need to do. How, Mr. Childers, you have anything ready?
I have, Mr. Kawan White is ready with Mr. Denowith. I don't see Mr. Denowith.
Yeah.
If you have Mr. Elman.
I think I'm currently the only attorney in the courtroom, so.
I'm sorry?
If we have Mr. Elman.
Mr. Elman, yeah, we're ready.
Ready on here.
I'm Perry, yes. I can probably get Mr. Elman.
Okay. He walked in and then. I need to start screaming and yelling. Then they'll all run in. Everybody will come in then. I gotta quit being kind and gentle. Snellman's here. Thank you guys for coming in. I'm gonna take a recess. No, I'm kidding.
Terribly sorry, Your Honor.
You're ready on Perry?
Yes, Your Honor.
Court does call the case of People versus Jimmy Lee Perry.
Good morning on this beautiful morning, Your Honor. Robert Ellman on behalf of Mr. Perry. Your Honor, as you may recall, last time we were set for exam, Mr. Perry had been transported into treatment over at Sacred Heart.
Yes.
I did call them Friday, and he was still in treatment. His tentative completion date was today. I've checked with jail staff this morning. He's not on the list of people here in custody, so I believe, based on those two things, that he's still in treatment at this time or in the process of completing and being transported back.
You're asking for an adjournment.
Yes, Your Honor.
Not a bench warrant.
I need a little more coffee this morning. Apologies.
And there's no objection, I presume.
There is, Your Honor, I do have my witnesses present, and this is the second time they've been present. I understand, and Mr. Elman has been very good about email correspondence with me regarding his client. Is there a way that we could continue for a prelim on a new date, or perhaps I'm gonna put my witnesses on standby, and if Mr. Elman confirms his client, because there's also been a misdemeanor offer.
Got it.
For use.
And maybe, Your Honor, not that I want to push this case in the wrong direction, but maybe it's better to just set it out for PCC and then.
That's not happening.
Okay.
I know.
I'm just.
I know,
checking.
and I don't know why Alman did, but
Like I said, Your Honor, I need more coffee.
because you're trying to irritate me. That's
My
a fine
apologies.
job you're doing. So here's what I'm going to do. His expected completion date was today.
Correct.
So what I will do is I'll adjourn it to my next date, which is February 3rd.
Yes.
And then I will indicate that the prosecutor's witnesses can be on call.
And Mr. Childers, I'll let you know as soon as I have more information.
All right. So this matter, preliminary examination in person, February 3rd, 2026, 9 a.m. before me. His bond at this time will continue. Thank you.
Thank you, Your Honor. Have a great day.
You do the same. Here.
It would be Mr. Cook and then Mr. Cooper.
Oh, okay.
Judge waited, then waited some more. As attorneys failed to appear and phones rang, patience ran out and the courtroom felt it instantly.
Why was Glick hiding? Why was he hiding?
I was meeting with the victim, Your Honor.
No, not you.
As the docket continues, the judge becomes increasingly frustrated by the absence and disorganization of attorneys, openly questioning where prosecutors and defense counsel have gone and expressing visible irritation at being ignored. Phones ring, attorneys scramble, and the judge sarcastically remarks that patience has run out as staff attempt to locate missing lawyers. Despite the disorder, the court resumes and calls the case of People versus Jimmy Lee Perry. Defense counsel explains that the defendant was transported to an inpatient treatment facility and may still be completing treatment, prompting a request for adjournment. The prosecutor voices concern about witnesses being present for a second time, but after tense back and forth and sharp remarks from the judge, the matter is adjourned with witnesses placed on standby and a new preliminary examination date set.
Mr. Glick was hiding.
I was talking to my client. Your Honor.
Oh, okay. No, I didn't see you in the room, and I said he must be hiding.
I just want a surprise appearance.
No.
We were the first people here, Judge.
Were you? All right. Let's do this.
I didn't drive from Detroit. I'm at a hotel. I
Pardon?
had to go to the jail at night. So I say, you know what?
Stay around. Got it. Court does call the case of the People's State of Michigan versus Stephanie Marie Cruz Mena.
Good morning, Your Honor. Raymond Cook for the People.
Good morning, Your Honor. Jeremy Glick with and on behalf of Ms. Cruz Mena, who's approaching the podium. And Your Honor, if I can just have 2 seconds to tell my client something.
Your name, ma'am?
If you can say your.
Stephanie Cruz, Mena.
All right, we're ready to proceed, Your Honor.
Ready? All right.
This is the date and time set for preliminary examination, and since people are unable to proceed.
And Your Honor, given that the people are unable to proceed, we'd move to dismiss this case.
People being unable to proceed, this case is dismissed on the. Hold, sir. I don't know who you are and why you're interrupting my proceedings. And why your phone is on also. Who are you?
Andrew Stevens, I'm a victim. I can check in. Your Honor, can we pass this matter?
Hey, go back. Go back.
Thank you, Your Honor.
Sir, that is not the way that you conduct yourself in here. If you needed to get the prosecutor's attention, there's a way to do that, but interrupting what I'm saying is not going to be good for you. Understood? Thank you. That's it?
Yeah.
Well, now I have attorneys, but are they ready? Ms. Yagi, how are you?
Good morning, Your Honor. I'm doing well. How are you?
You're doing well. Are you guys ready on anything? No?
No, yeah, but hopefully very soon. I just have to talk to Mr. Cook very quickly. But we did talk this morning. We have to talk a second.
That's fine.
Thank you.
Mr. Cook has to talk on that case. So you have nothing else ready?
For right now, I don't know if the defense attorney is ready on Haffner Cantor, but I'm ready on that one.
Who's the defense counsel?
Lauren Green.
Who? Where's he? You wanna know what? Why do I feel like I'm being, like, ignored? That doesn't work well. Where are all the attorneys? I don't, with all due respect to those that are here, but where is Mr. Warren Green?
Would you like me to check next door? Your Honor? He is next door. I just came from next door. I can go get him, Your Honor. Thank you.
This is going well. Should have stayed back. Should have stayed in bed. It showed up around noon and everybody would be ready to go. Well, 2 cases and are you lost?
Always. You don't look happy.
Why? I'm just looking to do something, but not everybody's cooperating.
I gotta go get the prosecutor. I'll warm some other way.
Who are you going to go get? Is that something over here? Are you guys ready?
Pretty much. Just a little detail guy. I'll hurry up.
No, you won't. Yeah. Mm. It appears, Ms. Yagi, you were unsuccessful.
Your Honor, I was told that sworn screening cases being called next door. And so it's a very short matter. And so he'll be here with it.
Was he on the record?
He was not.
So he's telling me to wait.
Apparently.
Okay, well, court's gonna stand in recess. Court does call the case People versus Connor Rice.
Your Honor, Rob Dowd, Assistant Prosecuting Attorney on behalf of the people.
Ron Brown appearing on behalf of Mr. Rice. Good morning, Your Honor.
Good morning, sir. Your name?
Connor Rice.
Thank you.
Your Honor, today set for a preliminary exam. We are going to, at this time, dismiss counts 1 and 2 and have the case remanded to 14B on count 3 for domestic violence. There's an agreement to do 4A. But I do have one ask regarding bond conditions.
No objection to the dismissal of the felony counts.
And then it's going to be remanded for a pretrial?
Yes, Your Honor.
Or
Pretrial before Judge Washington.
what it'll do is counts 1 and 2 are dismissed. I'll continue to defendant's not guilty plea as to count 3. A pre-sentence or pretrial will be set
February 2nd at 9 a.m. before Judge Washington.
February.
Chaos continues as a judge openly comments on attorneys hiding, arriving late, or failing to communicate, warning that the courtroom is not a place for disorganization or disrespect. The case of People versus Stephanie Marie Cruz Mann is called, but the prosecution announces they are unable to proceed and moves to dismiss the case. Before the judge can rule, another interruption occurs when someone speaks out of turn, immediately drawing a sharp rebuke from the bench. The judge firmly reminds everyone that interrupting court proceedings is unacceptable and will only make matters worse. After order is restored, the judge stands in brief recess while attorneys regroup, making it clear that the court's patience is wearing thin.
Court does call the case of the People's State of Michigan versus Marshawn Smith.
Andrew Childers appearing on behalf of the people.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Smith, who's making his way to the podium.
You take your hands out of your pockets.
Well,
All right. I have your name, sir.
Marshawn Smith.
All right. I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of attempted resisting obstruction, 1-year offense. On a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That is correct, Judge.
that's right.
All right. Having sworn?
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give be the truth, whole truth, and nothing but the truth, so help you God?
Okay, I do.
Lower your hand, state, and then spell your name.
Marshawn Duell Smith, Marchandduellsmith.
All right. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that? You need your. Okay. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
Yes, I do.
Still wish to plead guilty?
To get this situation over with, Your Honor, like I mean to get this situation over with.
Your Honor, we're perfectly ready to hold an exam if Mr. Smith does not wish to plead guilty. I don't want him pleading guilty simply to get something over with. If he wishes to plead guilty, I'm happy to stand here next to him and do that. But if he doesn't, then I'm happy to hold the exam.
What do you want to do, young man?
Is it possible for at least for the month that I spent in there, I spent over at least 35 days and they're trying to get out on personal bonds. Then, you know what I'm saying, ended up with a personal bond on the 8th, didn't get out on the 8th, just got out yesterday. Like
you're talking about sentencing as opposed to the plea.
I mean, yes, you know, if I can give time credit for the time that I did spend.
I'm not the sentencing, so I can't say I'm going to give you credit for time, sir.
And I have explained to him that he will get credit for the days he spent against any jail sentence, which I'm not anticipating here. But there's no promise from the prosecutor, or obviously you can't bind Judge Washington. But I've explained to him that he would certainly get credit for the time he's there, but there's no promise of a credit for time served only sentence.
But if I do proceed with the proceedings, then
if you what?
I say now, if I do proceed with the proceedings, then I would get what, like,
you mean with a preliminary exam? If you do that, what are you? I'm trying to figure out what you're asking.
If I do, you know what I'm saying, take the preliminary exam, I mean, what would happen? What will go?
Well, I don't think anybody can say what will happen, but if the people show their case, you'd be bound over to circuit court, and you'd then go to appear on what effectively is what's called a high court misdemeanor or felony charge before Judge Conkey.
This wasn't about the case anymore. It was about respect for the court, and when that line was crossed, the judge made it clear.
Your Honor, if I may, we made the misdemeanor offer that is available for Mr. Smith today. I cannot promise that that offer will be made again in circuit court.
Listen, young man. Again, like I said, I have to make sure that folks understand what they're doing and whatever. So here's what I'm gonna do. I know exactly where we left off in this plea. I'm gonna step off for 15 minutes. I'm gonna let you have another conversation with your attorney and then decide what you want to do. Okay? They've got their witnesses here. Everybody's ready to go. Or you can take the plea or not listen to me and start walking away. All right. Okay, court's gonna stand in court recalls case people versus Marshan Smith.
Michael Gandy, Assistant Public Defender for Mr. Smith. State your name, Mr. Smith.
Marshan Smith.
All right, Mr. Smith, we had just begun the taking of the plea. You had been sworn. We're changing this.
No, Your Honor, I believe I've had a chance to speak with Mr. Smith. I have gone over his right to an exam with him. I believe he wants to proceed with the plea, Judge.
All right. So, sir, understanding all of what I previously told you, do you still...
Court resumes with multiple cases moving quickly, including People versus Connor Rice, where felony count are dismissed and the remaining domestic charge is remanded for pretrial proceedings. Immediately after, the case of People versus Marshawn Smith is called, where the defendant indicates a plea agreement involving attempted resisting and obstructing a police officer. During the plea colloquy, the judge pauses the proceedings when it becomes clear the defendant may be pleading guilty simply to end the process rather than out of true understanding. The judge emphasizes that pleas must be voluntary, informed, and deliberate, offering the defendant time to consult privately with counsel rather than rushing into a life-altering decision.
Wish to plead guilty to this charge?
I plead no contest, yes. Is that what I'm supposed to plead or no, not guilty?
Well, what is...
I thought you were going to plead guilty.
Oh, yes. I mean, guilty. I'm sorry. Sorry. My bad. Yes.
Okay, so you're going to plead guilty to this charge?
Yes.
All right, so to the charge of attempted resisting and obstructing a police officer, how do you plead?
I plead guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind?
Yes.
Yes?
Yes.
You signed an advice of rights form, is that correct?
Yes, I did.
Any question regarding any of those rights?
No.
Okay, I need you to look at paragraph 5. You'll see a copy on the podium. Now, those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, I am not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily?
Yes, I am.
Of your own free will?
Yes.
And because you believe that you're guilty of this offense?
Yes.
All right. Get the date. Do I have hang on a quick second. There's a copy for you. On the date of December 9th, 2025, at the location of 456 Haynes Street in Ypsilanti Township, Washtenaw County, State of Michigan, did you come into contact with a sheriff deputy?
Yes, I did.
All right. And what happened?
I mean, I could start, you know what I'm saying, from when I got out of jail that day. I did receive tried to call for a simple standby. I guess, you know, something in that didn't happen to where I was able to go to the place. But when I went to my place, you know, I was greeted by the officer. He did tell me to stop, and I didn't stop. I ran.
Okay, so the officer was there. This is a place you weren't supposed to be without a civil standby, right?
I mean, yeah, I did.
Okay.
For a civil
And so you
standby.
got there and the deputy, you were starting to proceed to it and the deputy told you to stop.
Yes.
And you'd admit that the deputy telling you to stop, that was a lawful command and he was performing his job in doing that, right? And you failed to follow his order or his command.
Yes.
Correct? Okay. All right. Sir, I do have to advise you that from the time that I accept your plea to the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, the court would not be, you would not be able to withdraw your plea, and the court would not be obligated to follow any sentence evaluation or recommendation. You understand that?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, not from the defense, Judge.
And have I complied with the court?
Keep us satisfied, Your Honor.
Defense is satisfied, Judge.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this case will be
February 19th at 10 a.m. before Judge Washington.
February 19th, 2026, 10 a.m.
Yes.
10 a.m.
And
before Judge Washington. Yes, sir.
where is Judge Washington's court? Is this the same building?
No, it's not in this building. It's over off of Huron River Drive in Ypsilanti Township.
I'm not.
Okay, what happened is you can call over to the court. I think it's on that sheet, the 14B.
Is that by a Kroger's, if I'm not mistaken?
The Kroger's and
is the post office right there?
Yep.
Okay.
You know where
I know.
Yep.
Yeah.
That's
because we had to go get our mail. We stayed in Arbor One in there. Yeah.
Got it.
Yeah,
okay. Yep. It's that court right down the street.
Okay.
Okay.
Sir.
All right. Thank you, sir.
February 19th at 10 a.m. Okay.
Yes.
I got it on here. Thank you.
Okay. Thank you.
After a recess, the defendant returns and confirms his intention to plead guilty, prompting the judge to carefully walk through every waived right, including the right to trial and appeal. The defendant admits to fleeing from a deputy after being given a lawful command to stop, establishing the factual basis for the plea. The judge warns that any misconduct before sentencing could eliminate the chance to withdraw the plea and formally accepts the guilty plea, dismissing the remaining count. Sentencing is scheduled for a later date before another judge, with the court ensuring the defendant understands where and when to appear. The clip ends with the courtroom finally settling into order after a morning defined by interruptions, frustration, and firm reminders that respect for court is non-negotiable.